Okay, so thank you all for joining us. This is the Housing Discrimination and Fair Ordinance training that we are conducting for service providers who work with the Low Income Housing Trust Fund. I appreciate you all joining us today. Okay, so yeah, I'm gonna just start us out on our agenda. So we'll do a welcome. We will have a presentation from CCHR, which is Chicago Commission for Human Relations, on housing discrimination and how to report that. And then we also are going to have a presentation on the Fair Notice Ordinance and eviction support that Department of Housing is providing. And then we'll have some time for questions at the end of both presentations, so you can feel free to ask questions and get to know. First, I want to introduce myself. I'm Aaron Johnson, he, him, his pronouns, and I work for the Department of Housing. I'm the Community Engagement and Racial Equity Project Manager for the Department of Housing. I'm gonna pass it off to Kristen.
Hey everyone, thanks for being here today. My name's Kristen Lee. I'm the Director of Compliance for Fair Housing for the Chicago Commission on Human Relations.
And then Joanne, do you want to introduce yourself?
Sure. I'm Joanne Newsom. I'm Deputy Commissioner here at the Chicago Commission on Human Relations.
Yeah, thank you. And so if everyone else can put their name, role, and organization in the chat, that just helps us keep a record keeping, just who's here. That will be helpful. But I'm going to pass it off to Kristen. And then Kristen, just feel free to tell me next slide whenever you want me to change.
Sounds real good. Okay, so today I'm going to talk about housing discrimination, specifically the Chicago Fair Housing Ordinance. It's enforced by the city department called the Chicago Commission on Human Relations. Next slide. So before we kind of delve in, I just want to kind of like take a moment to center ourselves and think about like, why are we having this conversation? So just kind of address the importance of fair housing. So the issues with Chicago housing stems from systemic issues of racism that have had long-term strong impacts on Chicagoans. It's affected families' abilities to build wealth over time, and it's impacted the ability for everyone in Chicago to have access to safe places to live, places where you can have access to good schools, short commute times to getting downtown for work, access to stores, restaurants, doctor's office, all those things that help make a community strong. So thank you so much for being here today to learn about how to help your clients file discrimination cases in their housing. So just a couple notes about the Chicago Fair Housing Ordinance. So every level of government has some sort of housing discrimination ordinance. The Commission's ordinance is unique in that it applies to all housing units, regardless of the building size or whether the owner occupies the unit. Next slide, please. So when you get a caller or you're meeting with someone and they start telling you about the issue that they're having with their housing, some of the key things you want to listen for that may key you into the fact that they may have a housing discrimination complaint in addition to whatever other complaints they may have, or possibly specifically only fair housing discrimination, is when someone tells you that an adverse action has been taken against them because of their membership within a protected class. Now that's a whole lot of words to just simply say, perhaps, they didn't rent to me and I think it's because of my race, or I saw an advertisement in the newspaper, or not the newspaper, I'm really dating myself now, sorry about that. But like, let's say someone is searching for an apartment and they're looking on one of the websites or one of the apps. Let's say they're on Zillow or Domu, and they see language that would exclude them from renting from the property that discourages them. You might see something along the lines of no children, or no section 8, or we prefer older residents, which may exclude families with children. Language like that would be a violation of the ordinance. Additionally, if someone might tell you, I was applying for an apartment, and the thing was that they said that because I had kids, they wanted me to pay a bigger down payment. I'm sorry, not down payment, security deposit. So something like that, different terms and conditions of a sale or a rental. So where the landlord or the person selling the property basically changes the deal because of the person's membership within a protected class. Additionally, if someone's lease is terminated because of their membership within a protected class, a situation like this may be, let's say, another example for a source of income discrimination. So someone lives in a building, and there may be let's say that their source of income includes a housing choice voucher, and other people in the building also have vouchers. Let's say the building sells, and a new owner comes in, and the owner tells everyone, I'm not participating in that program. And because of that, I'm terminating your tenancy. So potentially, the person would file a complaint, and we would investigate it to determine that. So that would be something to want to follow by as well. Additionally, harassment and sexual harassment, I'm going to go into that in a little bit more detail. And then failure to accommodate based on a person's disability or religious practice. Next slide. So the key to how you would distinguish between a case being a discrimination case versus a case that may come under the landlord-tenant ordinance would be that connection with the protected class. So it's that because of that distinguishes the two different types of cases. So a landlord might be a crappy landlord and enter the person's unit without any notice, and that would come under the landlord-tenant ordinance. But if or they might fail to make repairs, and that could come under the landlord-tenant ordinance. But let's say that the tenant or your client knows that has a reason to believe that the reason they're not making the repairs is their membership within a protected class. It's that kind of nexus, that key between the two, that would tell you, you know what, I'm going to tell them to file a discrimination complaint, and let's at least look into this and see if that's what it is. So just to kind of run through the protected classes: race, color, national origin, ancestry, religion, age, specifically over the age of 40. Disability. For disability cases, they can come in a couple of different ways. You may see someone who feels like the landlord did something to them because of their disability, or you may see a case where a landlord or a property owner denied a request for a reasonable accommodation which was brought because of the person's disability. So if you're assisting someone with making a request for a reasonable accommodation to their landlord, we always encourage you to put it in writing as much as possible. Be specific about what you want, but understand that it is a back and forth communication between the tenant and the landlord, an interactive process. Those are the words I was searching for. So then for bodily autonomy, this is a new one for the commission. It's effective as of February 1st of this year. And bodily autonomy refers to a person's self-governance over their reproductive health care and their own gender affirming care. So if someone thought their landlord took an adverse action against them because of a decision they made with regard to their reproductive health care, that's a new area of law that's protected, and they could file a complaint here. Reproductive health care could refer to contraception, preconception care, maternity care, abortion care, and counseling regarding reproductive health care. It's not necessarily limited to that. It's just some of the areas that are included. Okay, and so then the next protected class, sex. The protected class of sex covers pregnancy and sexual harassment. I wanted to highlight the protected class of sexual harassment because we are seeing an increase in incidents of sexual harassment in housing. This could be related to, with the pandemic, more people were working remote and attending school remotely. But it's important to note that a landlord can never subject the tenant to sexual harassment. And sexual harassment can be quid pro quo, where they're saying this or that, like basically, I won't charge you rent this month if you do X, Y, or Z with me. Or it can also be a series of incidents that like rise to the level of interfering with a person's enjoyment of their housing. So that could look like touching, inappropriate touching, statements made of a sexual nature, things like that. Especially, sadly, we're seeing children subjected to the sexual harassment in the environment when all of the children were working remote, or I'm sorry, doing school remotely. It became an opportune time. It kind of for some incidents. So just if you can just like encourage, just be sure to mention to your clients that that is an area that's protected, and God forbid that they be subjected to something like that, that's something they can file a complaint with us about. Going on, additional protected classes are sexual orientation, gender identity, marital status, parental status, military status, source of income, and retaliation. So retaliation would be specifically that the landlord retaliate, or property owner or property manager. That reminds me, I want to make a point about that. But specifically, it's retaliation for having had complained about discrimination in housing. So let's say someone said to their landlord, listen, I think you're doing this to me because like I feel like you're ignoring my request for repairs, and you're doing it because of my membership within protected class. And then let's say the landlord's like, I can't believe you accused me of discriminating against you. I'm terminating your lease. So that would be retaliation. I want to go into a little bit more information about source of income on the next slide, if you want to go on to the next slide. So source of income is the lawful manner by which an individual supports themselves and their dependents. The ordinance prohibits discrimination against people who use non-wage income as a source of income to support their rental or their purchase of housing in Chicago. So that could include, but isn't limited to, Section 8 housing choice voucher, Social Security, or rental assistance in some cases. Next slide. So it would be a violation to refuse to rent to someone because of their source of income. It would be a violation to make any kind of sign or online posting or advertisement showing that preference for a specific source of income. Most frequently, we see this in the housing choice voucher arena. We'll see like no Section 8. So if you have if you're assisting a client and they have a housing choice voucher and they're looking for apartments and they see this, they could file with our office. Additionally, a property owner can't say, oh, I don't want to, it's too burdensome. The commission has found that the administrative requirements for the voucher program are not overburdensome, so that's not a defense. And then a property owner cannot, subject the person to different terms and conditions of rental based on their source of income. Next slide. Oh, and then when it comes to minimum income requirements, frequently in the housing industry, it's common to see, 3 times the rent as the minimum income requirement. And as a general rule, landlords should treat all applicants the same, except when a requirement they have creates what's called like a disparate impact against somebody. And when you apply the minimum income requirement to someone with a voucher, that's going to eliminate all voucher holders from being able to rent at the property. So the minimum income requirement of 3 times the rent should only be applied to the portion of the rent for which the participant would be responsible. So, for example, if let's say that the rent was $1,200 and the CHA's portion was $900 and the participant's portion was $300, then that they would just need to show an income of 3 times the $300 of the rent. I think there was a question. I'm sorry, I forgot about the chat. Have there been questions? Let me just take a quick look. Does this include subsidies besides housing choice voucher? Does this apply to voucher subsidy? No, great question. Thank you, Mary. So Mary asked in the chat, does source of income protection apply to other subsidies? Yes. So if someone receives rental assistance, if the and other subsidies, yes, those are also protected, defined as a source of income. Next slide. Okay, so let's say something I've said to you today kind of rings a bell and you're thinking, you know what? That reminds me, I was just talking to someone about this and I think that they might have a complaint. Like, where do I go from here? What should I do? So to get started, have them call the commission's intake line. The telephone number is area code 312-744-5879. Again, that was 312-744-5879. And so we have staff manning the intake line Monday through Friday. As long as the office is open, someone's watching that line. And so an investigator answers the call and asks a few questions to make sure that the person who's calling is in the right place. We call it, do we have jurisdiction? And so the basic jurisdictional requirements to file here, as opposed to one of the other offices, one of the other levels of government, would be, did it happen in Chicago? So if for some reason you're working with someone who works outside of Chicago, but maybe it's still in Cook County, then you could refer them to the Cook County Commission on Human Rights. Or let's say for some reason they're even outside of Cook County, then there's the Illinois Department of Human Rights. But if it's in Chicago, you can refer them to us. And so over the phone call, we talk to the individual and let them know what information's needed for the complaint. A few notes on it would be, so assuming we have jurisdiction, we would tell them the next steps of filing. If we don't, we would make that referral for them. So let's say that someone decides that, let's see, so there was a question, can a landlord turn you down due to a 600 or less credit score? Thanks for the question. So landlords are permitted to have reasonable rental criteria as long as they apply it evenly against everyone. So short answer would be yes, but if the person you're working with believes that the landlord is lying and is just using that as an excuse not to rent to them because of their membership within a protected class, it's referred to legally as like a pretext for discrimination. You could also just think of it as like a lie, like they're lying to me. That's not the actual reason. And you have a feeling like, I don't think that they even check people's credit score and things like that. Then you can always file the complaint and we can investigate it to determine if in fact, did they actually run the credit and things like that. Okay, thanks for that question. So getting back to how to go about filing the complaint, there's a couple of different options. A person can either come to our office and work with us to draft the complaint. We're located at another slide. I'll have our address on the slide, but we're here. If someone wants to come in person and have an investigator prepare the complaint for them, they can come Monday through Friday between the hours of 9 and 3 o'clock. They want to bring with them the name, address, and phone number of whoever they're filing the complaint against. You can't file against a neighbor. You can only file against someone or an entity who has control over your housing, such as the owner or the property management company. You can file against a realtor. There is no cost to file a complaint with the commission. And in terms of timing, you want to make sure that they know that they have 365 days from the date of the incident to file the complaint. But if it happened before June 4th of 2022, then they still have 300 days. There was an update to that. Additionally, I want to just note that our services are available to everyone, regardless of the documentation status. So, and I want to note that we are a certifying agency for U visas. So if someone was subject to a specific crime in their housing, that overlaps with housing discrimination. So we most frequently would see this in sexual harassment in housing. So if someone was like sexually assaulted in their housing, the commission can participate in their process of going about getting a UT visa by being a certifying agency saying, yes, this person is participating in our investigation. Additionally, I just want to note that we can schedule interpreting services for all languages, including ASL, American Sign Language. Next slide. Okay, so a few other points about someone coming to file a complaint is that there's no appointment necessary. They can just come on in between the hours of 9 and 3 o'clock. And so they bring with them that necessary information to get the process started, the name, address, and phone number for the respondent. And then they'd meet with an investigator and they'd tell the investigator what happened. They'll come into a private intake room, and the investigator will want to be prepared to answer like the questions of like the who, what, where, when, and why of what happened. And then the investigator would type the complaint and come back and review it with them and have them sign it, and it's filed. Additionally, so let's say someone doesn't, they're looking for an apartment and they see an apartment advertisement, but they're denied the apartment, but they don't know who actually owns it. All they had was like an email address. Well, if they can provide, the commission can do a title search to determine who owns the property. And then they could amend their complaint to add the person's name. But the only necessary information we would have to have would be the address of the property, including a unit number. Then let's see, next slide. We also have the option, let's say it's hard to get downtown. We're actually in River North, we're at 740 North Sedgwick. But if it's easier for someone to just do it on their own, you can submit it online. Here on our our website is www.chicago.gov/CCHR. This is a screenshot of what our homepage looks like. And here where I drew the yellow arrow pointing down it says file a complaint. So you would click on that and just follow the instructions to submit it online. And as long as we're on the homepage, I wanted to highlight this as well. At the top where the yellow star is located, it says translate. If you were to drop down the drop-down menu, any city website can be interpreted into various languages. So I think that's just like such a great service for Chicagoans. Just wanted to highlight that, but that's not specific to the commission. It's all city websites. So, okay, next slide. So for every complaint that's filed at the commission will conduct a full investigation to determine whether or not there's substantial evidence. So an investigation consists of so the person who filed the complaint is the complainant. The person it's filed against is the respondent. So the commission sends a copy of the complaint to the respondent. They have to file a written response to the complaint. The complainant files a reply. Both sides submit their supporting documents and information about witnesses. The investigator assigned to the case will review that evidence, conduct interviews with the parties and their witnesses, and summarize the investigation. And then the commission will decide whether or not to have a hearing in the matter. So if actually anywhere in the process of the investigation, if the parties want to try to resolve the case via settlement, they can work with the investigator to try to, negotiate a settlement. We do encourage settlement, but no party's ever required to settle. Let's say we finish the investigation and we say that there is enough evidence, we need to have a hearing here. then if both sides are amenable, we'll actually have a formal settlement conference where they sit down with a mediator to try to resolve it. If it's not settled there, then the commission conducts a hearing, and both sides present their case to a hearing officer who makes a written recommendation to the Board of Commissioners, who represent all the communities of Chicago. And that Board of Commissioners issues the final decision about whether or not the ordinance was violated, and then what damages would be due to the complainant, the person who filed the complaint. Next slide. So just like a few notes about, like, so what's in it for the complainant? Like, what do they get in the end? So they can be awarded damages, including their out-of-pocket losses. So let's say someone ended up having to rent because they were denied an apartment because of their protected class, then they had to end up renting a more expensive apartment. They could look at what was the difference in that rent and for how many months have I been paying it. And they could, say that those are some of my out-of-pocket losses. They can also, at the hearing, testify to their emotional distress. So they could talk about, I couldn't sleep, it interfered with my ability to concentrate at work, things like that. And then can be extra penalties called punitive damages or over-the-top discriminatory acts. Additionally, the commission can order the parties to correct their discriminatory practices. That would be like take the ad down or something along those lines. And then if a party had an attorney represent them in the process, a note on that, you don't have to have an attorney represent you here, but if you do, there's something in the ordinance that provides that the attorney can ask to have their attorney's fees paid for by the other side, which is kind of an incentive for attorneys to take cases like this, so that and not to necessarily require payment from the complainant upfront. So, and additionally, there could be a fine paid to the city up to $1,000, and then a violation of the Fair Housing Ordinance could also affect a respondent's business and real estate licenses, as well as their eligibility for city contracts. Next slide. Okay, this is our contact information. I'll let you peruse it while I think some questions came up in the chat. I'm going to take a look at those. Let's see. Okay. Oh, okay. So we had a question in the chat that said, how do past evictions impact the right to refuse housing? That's a really timely question. Currently, there's some laws are trying to, there are groups working to pass laws to close eviction records. I would encourage you to Google the organization CAFA, CAFHA, Chicago Area Fair Housing Association. And they have a meeting coming up, possibly, I think it's this Friday, to give an update on how that law is progressing. Let me see. So it's Chicago Area Fair Housing Association. And then if I can find, when Aaron starts his presentation, I'll see if I can find the link to the meeting and I'll put it in the chat as well. Let's see. Next question. How long does the investigation usually take typically? So the investigation varies depending on what happens with the cases. If it's a full and like worst case scenario, so from the time the complaint is issued to the respondent, they have 28 days to respond in writing, and then the complainant has 28 days from when they get the response to do a reply to the response. It is a formal legal proceeding, so we have to give each side their time to get their documents in, and then we are short-staffed. Just a note, we will be hiring investigators shortly. So right now it's just posted for internal candidates because it is a union position, but stay tuned to the commission's page, or I'm sorry, the city's hiring page, just as an aside, but we are short-staffed, so things do take some time. In some cases, the cases will resolve via settlement pretty quickly, especially in those cases, like when someone posts something in an advertisement saying something along the lines where it's where there's no dispute, the evidence shows they did this and they were like, oh wow, I didn't know. Those cases could progress quickly. But a full investigation can take a year to 2 years in some instances. And that's sometimes there are things that come up in the parties' lives where they'll request additional time and won't be able to participate in an interview. So there's various factors that can affect how much time an investigation takes. Okay, the next question is, what is the relationship between CCHR and IDHR? Is there a preferred venue for tenants in Chicago? Does one have more resources to process complaints than the other? So CCHR is my office, the Commission on Human Relations for the City of Chicago. IDHR stands for the Illinois Department of Human Rights. The difference between the two, the main difference is that CCHR enforces the Chicago Fair Housing Ordinance, whereas IDHR enforces the Illinois Department of Human Rights, the Illinois Fair Housing Law. They're two separate laws. So conceivably, a person could say, file here and there. The second part of that question, is there a preferred venue for tenants in Chicago? No, the only place I would say would be like when you're talking about Cook County's Commission on Human Relations, we have a work share agreement with them where if an incident happened in Chicago, then Cook County refers them to us, to the Chicago Commission on Human Relations. And then for the final one, does one have more resources to process complaints than the other? I can't really speak to their resources necessarily. Because what we like to say as the commission, as like a smaller office, is that when you call us, you get a person on the phone who will talk to you and answer your questions. Sometimes with a larger entity, it's more difficult to get that personal contact with a person. So that might just be something you keep in mind. Or I hope that helps answer that question. Let's see. Calendar days or work days. The question was, in terms of time, I believe that refers to the timing, that how much time a person has to file a complaint, and that refers to calendar days. So if the incident happened on or after, so more recent than June 4th, 2022, they have 365 days to file the complaint. If it happened earlier than June 4th, that was before the ordinance change. So if it happened before June 4th, 2022, the person would have 300 days to file the complaint. Okay. And next question, I routinely have property managers tell my case managers that they intentionally price units over the fair market value of how they want me to pay. So I can see such a hope this. That's interesting. So if there is a case where, let's see, so if you're helping someone who's looking for an apartment and they think that it's listed for a higher rent, they could file and say, like, I believe that there would have to be like that individual was being charged a higher rent because of their membership within a protected class. In terms of it's a really interesting question. In terms of if you're talking about like a widespread investigation as to intentionally pricing units higher to avoid working with subsidies, it's something to think about. It's an interesting point to give. The only thing is that, like, if they're getting those rents, then it's supported by the market, not necessarily referring to the fair market value. If anything, I think the advocacy part comes in with, maybe advocating for higher rent determinations.
Can I add something? Yeah. That's something really quick. So if it's a case manager, I'm assuming these are fair housing advocacy agencies. If you believe that a property manager or an owner is discriminate against people who have vouchers or other rental subsidies, your agency can file what's called a frustration of mission complaint, basically saying, well, we're in the business of assisting people to find housing, and us having to stop and investigate whether this is a discriminatory action on their part, artificially raising the rents. If you have to stop doing that, you can come and file a complaint with our office saying that property manager is frustrating your mission, and that you want to recover damages for that. A lot of times it's not a lot of money at stake. It's difficult for an advocacy agency to prove loss of damages. However, if you have to divert your resources, which in the like for staff time to investigate something like this, you could definitely recover damages, and it would be a way to educate property managers against doing that, because they still have to take accept applications, even if they think the CHA will not cover that. They still have to accept the application and have the CHA come back and say, that's, we will not subsidize that particular unit.
Hey, Joanne and Kristen, I see in the chat, one person mentioned, which is true, that like not all subsidies are the same. So some use different ways to do the fair market rent, and some can go above that. So that's just like some subsidy programs will pay a bonus or something if they have the money for that.
Okay.
But then the follow-up question was, can you speak a little bit more to frustration of mission?
So it's basically saying that our agency is a housing advocacy agency. We are in existence for the purpose of helping people to find housing, including people who have who need affordable housing, including people who have housing choice vouchers. That's what we're existing for. If one of my clients goes to your place and is trying to get, trying to apply for a unit, and we believe that the rents are artificially high, we then have to stop, divert our resources to investigate that. That's considered to be a frustration of your mission and a diversion of resources. Is that any clearer? I hope.
I don't see it in the chat right now,
Okay.
but I should also do my part of the presentation just to make sure we have time.
Yes, I'm sorry.
No, you're perfectly fine. And then if people have questions at the end of mine should be a little shorter, hopefully. But if people have questions at mine, you're open to ask questions about anything that you have heard about today. So we'll just bounce off of each other. So I'm going to share my screen again. Great. And you all can see my screen? If someone can just say yes, because I can't see you all.
Yes.
Yes.
Thank you. So I'm talking about, let me go back. I'm talking about our fair notice ordinance and eviction support that the Department of Housing offers. So the fair notice ordinance, we've been talking a lot about fair housing a lot, passed in 2020. So it's a relatively newer ordinance. And so I would say what I am seeing a lot in my role, the Department of Housing develop, landlords and tenants don't know about this ordinance because it is new. It passed during 2020, the summer 2020. There's a lot of other things on our mind during that summer. So that's why I do think it's important for you all to know this and to share this information. So the fair notice ordinance is if your landlord moves to terminate your lease or raise your rent, under the ordinance, landlords must provide 60 days for people who've lived in their apartment for 6 months or for at least 6 months or less than 3 years, and 120 days of notice to terminate your lease if you've lived in your apartment for more than 3 years. So these rules apply to all tenants, regardless if they have a written lease or an informal month-to-month lease, so long as you have evidence of paying your landlord more than a month. That is important to have. So that's what's necessary to have. So that could be bank statements, that could be a receipt, that could be receipts from cashier's checks, so just or a cash check. So it's just important that people, or even like the Venmo or Zelle payments. So people just need to have evidence of them paying that person consistently. It does not apply if the eviction process has begun due to non-payment of rent or another violation of lease. So that's just FYI. But if the landlord fails to give the required notice, tenants have the right to remain in the apartment for the required notice period, or they may pay their prior rent for the required notice period. So I've been seeing this, a number of people, even outside of my role, my work, and just like friends that live in the city, like, you know, their landlords are not following this. It also expands right to cure, which if there is, if you and your landlord have worked on an agreement, you and the client and the landlord has worked on an agreement, you know, that can stop the eviction process. Oops, but I have more of that. Here, oh, so here this is, right to cure in the fair notice. You have the right to remain in your apartment and in the eviction case against you if you have paid all of your back rent owed. You pay any court filing fees your landlord has paid in your eviction case. Do not live in the same building as your landlord if your building has 6 units or fewer. And you are free to make these payments until a judge issues a formal eviction order against you, known as an order of possession. So it would be good, you know, for people if they can to continue to pay their rent, and again, they could have the right to cure. Again, this is a new ordinance as of 2020, so there, you know, a lot of people don't know about this. So other things I want to just mention real quick for you all is the eviction supports that the Department of Housing provides. One is court-based rental assistance. So something that we've been really sharing with people since the pandemic started really is that the only person who can evict you from your home is the Cook County Sheriff's Office. That's the only one who can tell you to leave. We also a lot of times will get an eviction notice, you know, a 5-day notice or 10-day notice, and they think they have to leave. They do not have to leave at that point. And we also encourage people to not leave, but also to go to court because we have court-based rental assistance. What that means is in the Cook County Legal Aid for Housing and Debt, also known as the CLAD program, that helps connect people in it's called the Early Resolution Program, where they help divert people from court cases and put them in with case managers who can help on mediation, but also providing rental assistance, either 12 months back or 3 months forward. So again, it's important that you're telling your clients to make sure they're going and getting the help. Rentervention is this other resource that I have, and these are linked in here that I'll send out after this meeting to you all in our renter and landlord rights and responsibility booklet. The other thing is this Rentervention, though, it is legal support that we provide. Also part of the early resolution program is not only the rental assistance, but it also is the right to counsel program that we are piloting with $8 million in recovery funds. So this provides free legal representation and legal support to people in eviction cases who are under 80% of the area median income and has some impact of COVID, which most people do in this case. The government's very flexible on that definition. So that's another place for people to get free legal support. But you can also always go to Rentervention. You can tell your clients to go to Rentervention if they have legal questions. That's from the Law Center for Better Housing, which is another delegated agency of the Department of Housing that provides tenant-based legal aid to folks for free. So that's all that I have on my presentation. I'm going to stop sharing. Maybe. Okay. Yeah, so if there's any questions that y'all have, that I'm going to invite this up to everyone about anything that people may have questions on. I also say you can feel free to use the let me just raise hand feature. That's why if you go to the bottom of the screen and you click on reactions, look at a smiley face with the plus and click the raise hand, you can also unmute yourself and talk if that's easier for you instead of putting in the chat. Juanita, feel free to unmute yourself. But can you unmute yourself? I think I may have to ask
I
you.
did. I was
Okay.
able to unmute.
Great.
My question was for the court-based rental assistance. We as case managers cannot help our participants without them heading to court first. Are there any programs that we can actually assist and fill out applications for our participants prior to that? Do they have to get to the court-based part, or is there something that a case manager can assist?
Yeah, at this point from the Department of Housing, our funds were exhausted for the citywide program. So we only have court-based rental assistance at this point. The Department of Family Support Services has their rental assistance program, also shortened to RAP. That opens throughout the year. So I would just say keep an eye out on that. And then through All Chicago sometimes has a rental emergency fund as well. So those are places to look at to see if those applications will look. But for the Department of Housing, you're correct. The only thing that we have open is the court-based, in which they're put into the program for that. But don't, like, that's what I'm saying, is make sure that people go to their court case. One that helps, helps with their judgments and hopes. And if that's the case, if they do any of these things and they, they come to an agreement, even if the agreement is moving out of the home, through any of these programs, that eviction is not put on their record. Okay, if there are no other questions, I'll give 10 minutes back to you all on this lovely rainy day. So I do appreciate you all taking the time. I have this recorded. We'll send out slides and recordings probably early next week. And along with some other resources for legal aid and information from CCHR on how to report discrimination. But I appreciate you all taking the time. Hopefully this is informative for you and your clients. And please share this and share it wide. Thank you all.